Hi, everyone. Welcome. Welcome to our fourth webinar addressing the legal impacts of the coronavirus on K-12 schools. My name is Jackie Gharapour Wernz, and I'd like to reintroduce our panel. So we have Shelli Anderson.
Hi, everyone.
Nicki Bazer.
Good afternoon.
Fattore Crumley.
Hi.
And Jennifer Smith.
Hi.
So first of all, some housekeeping, some light housekeeping. If you'd like to ask questions, please use the Q&A function at the bottom of your screen. During the first half of our webinar today, we're going to answer questions that we received during the registration process and also by email. And then for the second half, we plan to take live questions. So please put your questions in that Q&A function. We're not able to easily answer questions with respect to in the chat function or raising of hands. So if you can put those questions down there, that would be great. If we don't get to your question, either that you sent us beforehand or during the webinar, in some cases it may be because the situation is really case by case specific. And so we encourage you, if you still have questions, reach out to one of us. You can always find more information on our website, which is franczek.com. And again, please feel free to reach out to any of us afterward if you have any more specific questions. Okay, so let's jump into our first question. All right, Shelli, I've got one for you. In previous webinars, we advised against taking temperatures of employees, and we had the question of the latest CDC guidance encourages employers to take temperatures of their employees. What's your current recommendation?
My current recommendation, Jackie, has not changed. I still do not think that, we're speaking obviously to school district administrators and board members right now, and I think in the context of that group, we do not and should not be taking temperatures. I think that, the reality is that people need to be very clear with those people who are deemed essential and coming to school, that if they feel sick, if they don't feel well, or if they feel like they have a temperature, they need to report that immediately and then not report to work. I think that it's just putting the individual who's to take the temperature, who may not be their regular job, putting them at too great of a risk, and putting the risk of what if, what are they going to do with that information? What if they don't do it properly? What if you don't have the PPE necessary to make sure that that person's not going to get ill? And I really think it's something, we have so few employees typically in the building at the same time, and oftentimes we're able to move people around and reschedule them in the event someone's not feeling well. So I think we have to have some level of trust with people and let them know that, we're going to be fair, but that we do not want anyone in the building who is going to be, not feeling well at all. So despite what the CDC is saying, I think in the context of schools, I still do not recommend taking temperatures.
And Shelli, don't you think that's because of the stay-at-home order now? I mean, that could evolve, wouldn't it, once we have full buildings again and we're, monitoring and track. I don't know if it will, but don't you think it's because of the situation right now with the stay-at-home order?
Yeah, absolutely, Jen. I think it's just fluid. I think we're going to have to be looking at this, kind of every day as things change, as our circumstances change. But right now, given the people who are actually in the building and what they're having them do, I think you're right. If everyone's coming back, it might be different. But for right now, I think we just follow the other kind of precautions that we can take.
Oh, Jackie, you're on mute. Jackie, you're on mute. We'll
also in the employment sorry about that. Also in the employment space, we've gotten a lot of questions about the FFCRA, the Families First Coronavirus Response Act. So Shelli, can you just give us a sense of what impact we're seeing from the FFCRA on schools?
Yeah, I think that in terms of the piece related to sick leave and the individuals not feeling well, or if someone has actually has symptoms of COVID, that's going to be different, and we're likely to see that come up in the school context. I have seen it in a few instances, really not that many at this point. So that I think throughout the entire work groups we could see that. With respect to the piece of the FMLA and the enhanced eligibility for FMLA, I don't think we're going to see that come to play that much with respect to our teaching staff, because the issue is really, are you able to not able to telework, such because your kids are home to take care of them, and because so many of our teachers, or all of our teachers, are doing remote learning, it's going to be a very rare instance where a teacher cannot perform that telework while at home, that they would be eligible for that FMLA leave, in my opinion. I don't know if anybody feels differently or has seen different things from the districts you guys work with.
No, I would agree with that, Shelli. I do. Luckily, we haven't seen a huge number of school district staff getting sick, and so we'll knock on wood on that. Our staffs seem to be healthy. We're seeing in a few cases, and again, what we're really seeing is those folks who are sick themselves. We're not seeing a lot of folks requesting that FMLA leave yet. Obviously, we may see that coming down the road, but so far, again, a few instances of sick leave needed.
And so just as a reminder for folks, if you're looking for some of the specific rules under the FFCRA, we've got a webinar out that you can review right now. We also have a podcast, the Coronavirus Labor and Employment Insights, that you can download that has a lot of those specific details. But we did get a few questions that were interesting. So Nicki, can we allow an employee to take a partial benefit day to supplement the FFCRA pay? Or could we just pay them outright for a full day and not cap it at the maximum daily allowable?
Right, sure. So just to remind folks, there are caps on the sick day amounts. So for an individual employee who themselves is sick, there is a maximum of $511 per day. And then for someone who's taking care of another person, it's lower than that. We've gotten a lot of questions about this. The answer to the question is yes, absolutely. So districts can do a couple of different things here. Certainly they can just pay employees up to the cap. They can also allow employees to take partial benefit days in order to supplement so that they get the full pay. We also know that there are some districts that are just giving, even though they're taking the emergency sick leave under the federal act, districts are paying folks above the cap and just paying them for their full salary for those days. So districts can certainly do that as well. Really, the caps are essential for private employers because the tax credit that they receive is only up to those caps. But for school districts, they're not eligible for the tax credit. So it is really in the district's discretion. And we are seeing some districts who are supplementing or allowing people at least to take some of their benefit time as well.
Okay, and then Shelli, also still thinking about the FFCRA, what are the documentation requirements that employers can or should be looking for to determine if an employee falls under one of the 6 categories?
Well, the interesting thing is, the rules have come out, but there haven't been any specifics with respect to what those certification requirements are in terms of the form that has to be filled out. We detailed this at length in an alert that we put out for anyone who's looking at it. It was dated April 3rd, 2020, as to what certification requirements, so what information the employer could expect to get from the employee, including how long they need to be out, what the reason for it is, under which category they're asking for the leave, and a whole host of other specifics. But in terms of whether or not there's a specific note from a doctor required or a form that needs to be filled out, whether it's for sick leave or for the enhanced FMLA, the Department of Labor has not come out specifically and indicated that there are a document that needs to be filled out. So right now, employers and HR folks should be looking for enough information from the employee that they are able to determine that they are eligible for the leave. And if you don't think you have enough information to determine that, seeking more information from the employee. More of a common sense approach to it, I would say, for now.
Okay, so switching gears a little bit, Dana, we've moved to remote learning, which in many cases means we are doing virtual learning. So we had a question about how do you deal with accommodations that would allow recording in the classroom or other confidentiality concerns?
So yes, we've definitely had questions about accommodations because I think of all the things that parents are worried about is my child going to get the accommodations that he or she needs to progress? And one accommodation is obviously recording the teacher, recording the lecture, and that might be that might run afoul of some student confidentiality rules if you're recording a whole Zoom class and kids are participating in that class and a student is recording that. So I've had clients think, really you have to think outside the box on this and think about what the student's real need is. I've had certain clients utilize support staff, so people that would be aides with students who are maybe not being utilized to a full extent, can sit into a class, take notes, and those notes can be emailed to the student after the class, so they can, aides can contemporaneously join these classes and perform some of those functions. If they really need it in an auditory form, you can certainly alter consent forms and try to write a consent form that will make it very clear to the student that they are only to record at certain times or record for certain purposes, and that they're agreeing that they won't share, and if they share, the accommodation won't be provided in that format any longer. Jen, do you have any other ideas?
No, I mean, we're cautious to, obviously that's an accommodation that you only do if it's absolutely needed and there's no other appropriate accommodation. So I think in most cases, I really like your idea about using aides. It gives a good idea for you know, using that service. I don't have other ideas. I think we have a limited toolkit right now, and those seem to be pretty much all we're dealing with.
That makes sense. All right. I know we're kind of jumping around back and forth. We're just gonna keep taking these questions as they came to us. So the next one relates to MOUs, or Memoranda of Understanding. So Shelli, I know you've been working with a number of clients on these. Why are they necessary, and do you need them with every employee group?
Sure. So I think, just to be clear, because I think people call them different things, an MOU or an MOA, so a Memorandum of Understanding or a Memorandum of Agreement, is typically something that supplements your collective bargaining agreement. So it is something that the parties, the union and management, are coming to an agreement on around something with respect to the terms and conditions of the employees' work environment. And so how they're going to handle, for instance, remote learning, if that has come up with as something that's outside the scope of the way they regularly handle it. Every employee group does not need this. So for instance, if your custodial staff are just coming in doing their typical work, that would not be a group that you would necessarily need an MOU with, even if you were giving them some more generous benefits than you may have otherwise done. So I know that I work with a number of districts who are rotating their custodial staff and giving everyone a day off a week. We did not enter into an MOU to do that. We are just letting them know that there's not as much cleaning that needs to be done, so they're giving them that additional benefit. With teachers and the work that needs to be going into remote learning, in most instances, I am seeing districts enter into agreements with the teachers with respect to, for instance, how long of the day they need to be available to students, what office hours they need to keep, things around that nature. What happens to evaluations? What happens to sick days? So I've seen a lot of different pieces that come up with respect to that have been agreed to with the union. So I would say that I'm more often than not seeing with teaching groups some support staff, but again, it's not necessary. I think it's just important that you work with someone who has kind of experience in these areas to make sure that you're not committing to one thing and on the other end of that, getting yourself stuck with something you might not be able to get out of at the end of this period. But again, I would say that an MOU should only be to the end of this school year. It should not go on beyond, even into the summer school, is my recommendation if you can help it. Dana, anything else on that? I know you've been dealing with this too.
Yeah, I think I absolutely agree with everything you've said. I think that there's been a lot of situations where, we might have an MOU or an MOA, but we just have sort of a handshake agreement. And I do think that when job duties are related to what they would normally do, sometimes staff are just not really requiring, the union is not asking for a formal MOU, but just changing their duties a little bit. I think the example I gave of the para educators working in different ways, maybe you don't need that person checking out books anymore. But as long as they're in agreement and the union leadership's in agreement that they're going to be doing something else temporarily, you should go ahead and pursue that so that you can serve as many kids in the ways that we have available to us.
Okay. Now, our next question relates to social workers. So social workers have shared a lot of concerns about being responsive to students during remote learning. Is there any liability risk if a social worker doesn't respond promptly enough? And are there any tips on how to mitigate those risks? Jennifer?
Sure. So I think one of the things, Shelli just mentioned establishing office hours. So same would be true for your related service personnel. You have office hours and you communicate to those office hours to parents generally, and then that's the expectation. Now there should be no expectation that social workers are an emergency line where that's where you go for emergency services. I think that's where there's a lot of concern, because in the school setting, they really do play that kind of role where they're triaging emergencies, but it's not possible in the home setting. It really isn't. So no one should have that expectation. Some districts are establishing that affirmatively, giving some sort of notice or reminders. Here's who you should contact in the event of emergency. I think you need to be thoughtful about how that's communicated. Some of them are a little bit alarming, like, you know, call 911 if, you know, telling students, call 911 if you're in physical safety. I think we're all a little stir crazy now, and if parents see those kind of messages, the school is telling my child to call 911, it might come off the wrong way. So you want to be a little bit careful, but certainly office hours and setting just the expectations that this is a related service. So right now, social workers are supporting related services, always support the instruction. So what can they do to support a student's access to remote learning right now? That's the scope. So a lot of other home needs or personal regulation, it's just not their role in this environment.
John, have you heard anything about like nurses in that context of how they're helping support, kind of in that support role, or school nurses?
Wow, that's a good question. I have not gotten any questions. Have you, Dana?
A question on that. And actually, I won't call out the district, but I've had some of the school nurses, because they're getting paid and because they have a limited role, they have been sharing sort of being on call. And then when they're not on call, they go and volunteer. They have responded to the call for volunteers by either the Cook County Department of Public Health, and they have been out in the community doing that volunteer work, which I think, you know, someone asked me if they could do that. That was a client question, because they were concerned that maybe they'd be exposed. But of course, none of us are in school now. So if a nurse did want to volunteer and use his or her time that way, you know, I think that's a commendable use of the time, and I think the district should allow that.
And the reason I asked is because I was wondering how it came up in that context, is I've had the same inquiry, and not necessarily on a volunteer basis, but for hospitals actually reaching out to school nurses to say, for RNs, can you come in and work? And the question I've received is, what if second shift, they want them to come in, starts in the middle of the day, when technically that's when they're supposed to be being available under our remote learning plan, and really being flexible around that and entering into an MOA with respect to that specific work group, to be clear that, you know, given that what they're being expected to by the district, obviously we want to make sure that they are able to go work in that second job in that position without opening the door for every employee group to be able to do that, while they otherwise should be on that kind of 5 o'clock hours to the extent they have them.
Right.
So Nicki, it seems like we're still getting questions about equity issues. So between remote and in-person work by employees, some employees, or some school districts rather, have been considering the idea of hazard pay or things on that sort to increase the pay for those who have to come in. What are your thoughts on that?
Sure, yeah, and you know, I think our discussion about nurses really just highlighted some of this. We all of the different employee groups in a district have different job responsibilities. They have different work responsibilities that they have to carry out. For some, teachers are going to be focused on remote learning. For other employee groups, and you know, our food service workers, our custodians, they may need to be in the buildings. And we understand that that raises concerns, and so school districts should do everything that they can, of course, to limit the number of folks who are in a building at any time, and to follow our health official guidance about social distancing to the extent that they're able. So, you know, we have to understand, though, that different employee groups have different responsibilities, and some of those may take them into the buildings. And employees are responsible for carrying out those duties unless, of course, they are sick or eligible for sick leave or other benefit leave. So, you know, we don't recommend at this point paying hazard pay. I'd love to hear if other folks have been hearing that from districts, but, you know, we really encourage our districts to understand and to recognize that their employee groups play different roles, and some of those roles will take them into the buildings.
I think on hazard pay, if I can just make kind of one comment, I think that to the extent that I've gotten inquiries about that, should we be paying the employees who come in more than the employees who are staying at home? I think Nikki is exactly right. I mean, we have to recognize that different jobs have different requirements, and everyone should be following all the guidelines with respect to social distancing and making sure that the environment is safe, that the employees are coming into. So I do not see a need to be paying employees more who come in. I think, as I mentioned earlier, there are other flexible things that you can do, like giving a day off here and there. I would caution everyone, though, to remember that you may have in your collective bargaining agreement, I think I mentioned this in the last webinar we had, that there might be language that indicates that if an employee group is asked to come in while the school is closed, they do receive additional pay. To the extent that you have that in your contracts, you really need to be getting together with the unions and talking to them about what the real intent of that language was, because certainly it was not intended for anything longer than 5 days that you'd be paying an employee group above and beyond what you typically pay them. So sitting down and making sure that you're negotiating what the real intent of that was and what the impact is of it now, given how long we're likely to be out of school.
Okay, our next question is about summer school and hiring. So we had the question, we're planning for summer school, we're actively hiring. Any predictions it will be required to pay anyway if we're unable to hold summer school? What should people do? Shelli, you have thoughts on that?
Yeah, so I've gotten this question a lot from people who are actively hiring for summer school, which I think is great. I think summer school is going to be even more popular this year than it has been in past years. I would say that right now, under the mandate we have from ISBE coming out of the joint statement, is that everyone is to get paid at least right now through April 30th. I would say that we don't know what specifically is going to come out after that. I think we're all pretty confident that we're not going back to school after April 30th for this school year, so they'll have to have something that comes out with respect to that. With any hires, though, I would make it very clear that you are hiring them to the extent that you actually are running summer school or in-person summer school, to avoid any argument that that person somehow due compensation if you don't actually run summer school this summer or not in the way that you intended to do so. And that's the same for people who are dealing with your current staff who typically teach summer school. I'd be really clear in any sort of agreements that you have that anything with respect to continued pay, especially for work not performed, ends at the end of the 1920 school year, and then we can address what happens after that depending on what the world looks like.
Okay, Nikki, is there any update? We've asked this in, I think, all of our webinars so far. Is there any update from ISBE on whether days before March 17th need to be made up?
We will leave you in suspense once again. We have no update from ISBE as of this point, so we are still awaiting. We know that ISBE is very busy. They just issued more guidance yesterday. I know they're tackling a large number of very, very important issues, so not to make light of that, but we don't know what they're going to do. Shelli, I know this issue has come up for you quite a bit in terms of people might say, well, we're just talking a couple of days here, but it seems to have some importance with at least some of the MOUs you've been talking with about.
Yeah, because right now, the real question is, do they have to be made up? So when you're looking at the number of days the teachers have to engage in the remote learning, or the number of days that parents have to, still have their kids, attending school and making sure that they're signing in the morning and what our summer is going to look like, that, while it might just be a day or two, it really does matter to families. It matters to our staff to be able to say, right now there's so much unknown in our world, and even having an additional piece that's not known, I think gives people some level of anxiety. So I agree with Nikki. ISBE's doing a phenomenal job putting out all sorts of guidance on things. I'm hopeful that we get an answer to this one soon, because it's a school calendar issue also. So school calendars are typically changed in April. I'd say because this issue remains unknown, because the state of our world remains unknown, I would not recommend making any changes to the school calendar at this point and leave them with the emergency days still attached.
Okay, so speaking of missed school, we've heard a lot of discussion about how to address all of this missed school. So we've seen some media reports, suggestions of starting school early in August, even having students repeat grades. Do you guys have any thoughts on any legal issues that these discussions might raise?
Jackie, I'll start from a special ed perspective. I think it's a non-starter to have kids repeat grades, especially when you consider the point, we did not miss the entire year, and there is an expectation of ongoing learning. I would be shocked. I mean, that would basically concede that you failed to provide FAPE. So I don't see, in a way, you know, in a way it would. I just don't see how that is a good solution.
Yeah, I don't think it's a feasible solution, and I don't think it's a student-centered solution necessarily either. I don't think repetition of a grade and keeping people back. We have to remember that everyone is in the exact same position. Special ed kids are in the exact same position as regular ed kids. I mean, certainly there's going to be starting school early for everyone. I mean, I think Shelli would and Nicki would be able to speak to this too. I mean, there's labor implications to that. We can't just say school's going to start on August 1st if that's not what the contract says.
Yeah, I definitely think that there are employee bargaining issues involved here, labor issues. I have to say, Jackie, as Jackie knows, when she first sent this question out, there was a sort of a very spirited conversation about all of this. And, you know, I think the level of disruption right now that is existing in the lives of families, in the lives of students, in the lives of teachers, and certainly administrators, the idea of, you know, having students repeat a grade or starting, you know, midway through the summer when families are typically off and hoping to recreate at least some of their summer plans, I think would be met with a lot of frustration and difficulty. I think the point about, you know, thinking about a student-centric, you know, I think what districts probably need to really start thinking about is how to incorporate in the fall, you know, a real look at remediation and bringing students back up to, you know, first of all, our educators are doing an amazing job of remote learning right now. They're keeping students on track, but to the extent there are some, you know, some items that need to be covered again or you know, just brought up to speed on, I think that's really the focus where districts should be right now in terms of next school year. Again, we don't have any specific guidance from ISBE on this yet. We might yet see some, but our hope is, you know, that we can, you know, move forward in a way that is consistent with what we'd hope for next school year.
And I would say it's not only the academic piece. I think right now, I mean, the focus for next year, I agree. I can't imagine how this would work, the idea of any students repeating grades. But I think that in terms of the focus for next year, not only on the grades, but on the social emotional part that the kids are experiencing now. I mean, I have an 8th grader going into high school who's just now going to spend the, you know, second half of 8th grade without any contact with his friends, and going to high school is hard enough. So I think having our teachers be given the flexibility to focus on that when our kids return, as well as kind of any gaps that there might be academically because of the you know, nature of remote learning, and it's not there, you know, great teachers right in front of them. I think it'll be an interesting year next year to kind of see how that all unfolds. And we just need to give everyone the space to figure out what that looks like.
Such a great point, Shelli. I know I've got 2 kiddos who love their teachers this year, and they're going to be very sad to, you know, have it be over. But I think next year we'll see a lot of efforts to address it. Okay, next question. So what if you have a situation where a student is expelled and the expulsion was held in abeyance so long as the student participated in an alternative program and the student's not participating? What can you do at that point?
So this question has come up, and you know, it depends what you're using as your alternative program. We've had some clients tell us that some of the alternative programs are not engaging in remote learning, and that would be a problem because you did, especially if you held the expulsion in abeyance, you entered into an agreement saying that you were going to provide this alternative education and the student would participate in it. More frequently what we've had is we do know that the regional safe schools are providing e-learning opportunities for their enrolled students, but we've had students just drop out and not participate. And I think where you have that problem, obviously you're going to rely to some extent on the school that the student is placed in to reach out to the family and make contacts and do all those things that they would do normally during the school year. but then you also need to make sure that you follow up in writing with the parent about what that does to the abeyance agreement, because a lot of those abeyance agreements state that the student must participate in the alternative education program and indeed meet the benchmarks of that program in order to return to the regular education setting when the expulsion period is over. So if that's the case, you're going to want to revisit those agreements and give parents notice that the student is not meeting the requirements and is jeopardizing their ability to come back to school when the expulsion period is over.
Okay, so it is 12:30. We've only got a handful of questions, but I think maybe let's jump to those, see what we can answer, and then we'll jump back to some of the ones that we received before. So Jennifer, there was a question here. There are specific guidelines for diverse learner populations in regard to their confidentiality. Can you speak to that? Is that correct?
I mean, the key thing would be not identifying them by a category. So certainly on some sort of Zoom, where that's the touch point, you wouldn't want to call out a student and say, no, do you need any help with your accommodations on your IEP in front of the whole class? Or, you know, so the specific confidentiality would go to that, not identifying that the student as a different type of learner in any way. So in all the communications. I'm not sure if it refers to anyone else, if that question triggers anyone else to think of another type of confidentiality that would be particularly at issue.
No, I think that's right, Jennifer. I mean, obviously, all of the confidentiality laws that cover every student cover students with disabilities in equal part. And I think you've identified the key aspect that we think about when we think about privacy and students with disabilities, which is not to reveal in any way that the student has a disability or is receiving services under an IEP to the extent, you know, a teacher is, you know, engaging with students over Zoom or what have you.
Okay, another question actually, although I love my role of channeling Diane Rehm or Terry Gross, we did get a question from someone who I had a conversation with this week about copyrights and social media related to teachers and staff doing like "we miss you" videos that would then be posted to Facebook or in other ways shared. And you know, the difficult thing is that even though we know that videos, and especially with popular music, can be a really great way to reach students during this time and to make us all feel connected, the copyright laws are still in effect for the music that would be being used in the background. And so we talked through some of the ways that you can get around this. There are some free resources out there that have songs and music that you can use. There's also ability to license at pretty reasonable rates for some of the less popular songs. But when it comes to Bruno Mars and Lady Gaga, it's gonna be really difficult to use those and have it be a fair use. That's not to suggest that there aren't some circumstances, particularly on closed channels where you're just sharing with a small class and you're reading from a copyrighted work or even playing music from a copyrighted work, that can sometimes be fair use if it's for an educational purpose. But for some of these larger gatherings and just more fun connection things, you really are going to have to try to pay close attention to copyright issues. We got another question, also special education related. Are there any updates regarding the IDEA and expectations for related services which cannot be performed through a remote service model?
So there aren't updates as far as, so far there's no waiver of IDEA requirements. The status is pretty much as I said on the last webinar. There's certainly advocacy around that for the 4th congressional bill that's being worked on, but I have very low expectation that there would be any waiver, and I think that continues to be the trend. Even more so, a lot of the advocacy groups are arguing IDEA has enough flexibility in it already that there shouldn't be any waiver or any relaxation at the statutory level. As far as related service minutes, so if they're in the IEP, again, there's nothing in the law that we can say your not required to provide those. The most legally correct thing would be to get an agreement to the parent that that is not a supportive service in this context. And so an addendum to say during remote learning, you know, I've seen a variety of remote learning plans that people are doing as addendums. Here's the goals we're going to work on. Here's the services we're going to provide. And one thing that is not in all the forms, I would really encourage you as part of that process to document parent concerns and parent input. Because now more than ever, I mean, the tables are flipped. Parents are primary in how this is working and what supports are needed. So I think if I would say anything to just globally on the different kinds of forms I'm seeing out there, maybe add a parent input or parent concern section.
That is just so important, because I think we're assuming, without having that question being asked and recorded, we're assuming that parents are, you know, dying to have PT, and they may not be. That might not be their concern. And so you might be able to enter in an agreement where you're not going to have physical therapy, because physical therapy was really for the purpose of allowing the student to do some things in the building and to be mobile in the building, to access certain programs, certain opportunities in the building, which are no longer relevant. And they might really be worried about something else that you can do remotely. So I think, Jennifer, that's such a good, you know, don't assume, ask. And it does take time to ask, but that's going to make your remote learning plan more individualized and just better and more defensible when we're through this period.
I mean, so far the feedback I've gotten, I was a little surprised this week. It's more questions about parents don't want this service. Mm-hmm. How do we document that? Or they aren't responding to our outreach to them. What do we do about that? They aren't responding when we're trying to schedule a meeting or when we're trying to schedule a service. So it's been much less. Parents want all the IEP minutes and you aren't providing. I don't have a situation like that. It's the opposite. Parents aren't responsive, aren't engaging, and won't get back to us. So I think some of them would be happy to waive, honestly, some of the services that just aren't working in the home.
Right. It goes back to, this is overwhelming for everybody. And, you know, it's hard for parents as it is. So giving them that opportunity to really state what the essentials are for them in their homes, I think is so critical.
Okay, our next question relates to how can a district have an agreement when not all students have parental support at home to complete e-learning curriculum or lack of internet? Shelli, I saw you wanted to give some thoughts on that.
I think we probably all have some insight from different perspectives because we all practice a little bit differently and with different groups of clients. You know, I think that every remote learning plan that I've looked at for the clients that I work with has had some provision in there related to how to connect with all kids, including those who may otherwise not be that engaged in school, which you can imagine if they weren't that engaged in school when they were in session and attendance was being taken, it's going to be a whole lot easier for them to not be engaged outside of school when remote learning is going on. So to really have your counselors engaged in reaching out directly to those families and making sure that to the extent that they are not participating because they don't have the right resources, you are doing everything you can to get them the right resources. I mean, we see every day on Twitter, all of you who are listening out there in the world, the amazing job that you are doing, getting kids and staff all of this, you know, remote learning tools. And if it can't be by remote learning electronically, making some accommodation so that it can be done in another way, whether it's through packets or other materials. And I applaud our teachers and our administrators for being so creative. Really, this is about student connection, student engagement right now, more so than anything else, just finding a way to reach every kid to the extent that we can.
Yeah, I'm not sure if that question also was in connection to what Dana was talking about in terms of expulsions and kids who are engaged through our ROE programs. I think they are acutely aware, and I would agree absolutely that, of course, the lack of technology or a student's inability to connect or a parent's lack of engagement to allow that student to connect are certainly not things that should be held against a student. I think our ROE programs are acutely aware of the issues that in our alternative programs, those folks are acutely aware of all of the issues that these students face, and certainly in this condition. And that would definitely be something to pursue if there is a student who is not engaging in one of those programs before you move forward with any sort of action related to expulsion or further discipline, would be to dig in, as we always do, to try to figure out what's happening with that student, and is it those lack of resources that we need to address first, and then see if we can get that student re-engaged. Obviously, in those circumstances, the goal is to try to get students back on track and re-engage with those alternative programs.
I mean, it's an interesting fine line now with grades not counting, and students, you know, some of our older students are savvy enough to know, wait a second, this doesn't count against me. I don't have to turn in this work, so why am I going to do this thing that I don't want to be doing at all? So it is a fine line that I'm seeing teachers and schools walking of, we want you to engage, we expect you to engage. Yeah, you're not going to fail, you're not going to be repeating the 5th grade, but our expectation is that you engage if you can. So it's not, where it's not a lack of resources, you know, it will be interesting to see what, if that engagement does end up reducing regression. And I think that's the goal right now. We're trying to minimize regression, trying to get us across the bridge, and sometimes it's a lack of resources, but sometimes it's a lack of motivation, and maybe the tools aren't that engaging. So it is what it is right now.
Okay, and next question is, during the regular school year, aides only work with students under the direction of certified teachers. What are your thoughts about aides communicating and working with students if not in a Zoom or Google class with the teacher? What other roles for paras are suggested at this time? Dana?
So I think we need to remember that the whole aides working under teachers, that's when they're performing instructional services. So we don't want aides acting as teachers. That's what the purpose of that rule is. That doesn't mean that aides can't do other things. Aides can't check in. Aides can't make sure, you know, do administrative tasks for the teacher. If students aren't attending, aides could make a call home and say, you know, you're not a regular attendee in math, or, you know, it depends how they're assigned and how you reassign them. But I think those types of things aides can still do. They don't need a teacher to be supervising them directly to ask a perfunctory administrative type question that might facilitate student participation. What do you guys think? Shelli, Nicki?
Yeah, I think I would agree with you. I think that we have to be relying on aides for the reason that we were answering before in the last question about student engagement, is that, you know, our teachers who are involved in remote learning, especially those that have robust plans where the teacher is actually engaged with students and available for students for a good chunk of the day, that we utilize the other supports that the students are comfortable with and that we have in the district to make sure that those other pieces are getting attended to as well, even if it's just kind of a reach out to the student to say, hey, what's going on with you and how are you and why have you not been checking in, things like that.
Okay, the next question is there a class size limitation for remote learning? Thinking of ESY and what that could look like.
So I'll start off, and since we've had no guidance substantively on special ed, there's obviously the class size limitations haven't been touched either. I would not think that you could change class size despite remote learning. Again, it's about engagement between student and teacher and sort of monitoring by the teacher of the students. And I think if you increase the class size, you interfere with that process. You interfere with the amount of individualized attention that especially a special ed student might get from a teacher. What do you think, Jen?
Yeah, I wouldn't see a legal basis to change the class size right now. I don't know what the argument would be. Just like you could team teach something maybe, and I'm seeing teachers, like a grade level is collaborating, maybe one teacher is doing a video and another teacher is using it. That doesn't mean that they've merged classes though. I think it depends how we define it. The teacher who's responsible for evaluating those students and tracking those students is still doing that, even if she's collaborating with her colleagues. So I think there can be a lot of collaboration and maybe a larger group method, but that doesn't mean we would not want to violate the class size limits or the 70-30 rule.
All right, we've got a question. Is there a state requirement for us to take and report student attendance daily? Nikki, do you have thoughts on that?
Sure. Well, all we have right now is the most recent ISBE guidance on this issue, and what ISBE has said essentially is that they recognize the importance of student attendance related to ensuring that students are engaged. And so what they've asked districts to do is to create, or what they've basically said is districts are able to create individual attendance policies. So some sort of check-in or method of tracking attendance. What they're asking districts to do with this is essentially gauge which students are not currently engaged in learning and may need additional outreach or supports. So a lack of seeing a student checking in should trigger staff to reach out to the family to find out what's going on, what can they do to help. In terms of tracking attendance so that it can be reported to ISBE, ISBE has indicated that additional information will be forthcoming. We haven't seen any update to that yet.
Okay, and then we have a question of concern about staff not wanting to do remote learning for ESY. Many have their own children and this has been challenging. I see teachers wanting summer off and not being able to staff. So this is kind of a mix between a personnel and special ed question. Can anybody give thoughts on that?
So, I mean, obviously you might have that problem. I mean, that problem might come up at other times as well, just people not being burned out and not wanting to teach summer school. I guess that's one of those things that I would say, let's cross that bridge when we come to it. We don't know what ESY is going to look like right now. If ESY is in session and you have to staff it, we may have to look for creative ways to do that. You might have to hire teachers from other districts, open up after you post internally, you might have to post externally. Those are options that you can take in, under normal circumstances, and we just have to brainstorm that if that becomes an issue.
Okay, those are all of our live questions so far. If anybody has more, send them our way and we can jump back to them. But for now, let's go back to our questions that we received before. And one of them, one that we got a few questions on was the CARES Act. So Nikki, can you give us any update on what types of things the CARES Act money can be used for?
Yeah, absolutely, Jackie. So I know that this has been a source of considerable amount of questions and hope for the funds coming forward. I know districts could definitely use them. Just a reminder, there's different funds that may become available for schools under the CARES Act funds. What ISBE has really been focusing on is the main funds, which are the elementary and secondary school emergency relief funds. ISBE has, as people know, ISBE has provided estimates of what they think the state's going to get and what each district then would likely receive. Obviously, this is based primarily on the Title I allocation. So in their latest guidance, ISBE does summarize what those monies, what funds can be used for. They've also, in their webinars and their communications, they've highlighted that they can use, there's really a variety of things that you can use money for under these funds. Summer school programming, which we've talked about, transitioning students back into learning, another thing that we've talked about today, certainly. Strengthening infrastructure for remote learning right now, student access to technology and the internet, certainly. But there's also other purposes. A couple that we might highlight here is you can use the funds to provide principals and other school leaders the resources needed to address the specific needs of their individual schools. Mental health services, which I know a lot of districts are thinking about right now. And any other services that really allow you to provide that continuity of education. So under those main funds, those are some, but there's a wide variety of uses. And again, ISBE has some in their communications. We would certainly encourage folks to look back at the guidance on that. Additional funds may be coming under other streams, and they may have more specifics, but we do believe that they will the uses are similar in those similar kinds of activities. So.
And do you know anything about the timing on this, Nicki?
It looks like we're still waiting for that information. ISBE in its latest guidance indicates again that the U.S. Department of Education must actually release an application that will then allow ISBE to have access to the federal funds. It doesn't look like that process has been started yet. Once that application is released, ISBE will complete it and have it approved by the Department of Education. And then the CARES Act requires that they must release the state application within 30 days of the effective date. So hopefully we're going to start seeing some movement on this. The review, we're not certain how long DOE will take to get the application out and then to review the state's applications before approving them. You know, ISBE has certainly said that as soon as it receives that award, they'll get information out in terms of timing, but we really don't have those pieces quite yet.
And am I correct, Nicki, that at this point, we don't know if districts will be able to use CARES funds for things that they've already expended money on? Is that correct?
That's correct. We don't know yet. We think ISBE is looking into this as well, and we'll hopefully get some guidance out on that so districts know.
So we have a couple more live questions. So first of all, are there any concerns with self-contained teachers conducting small group instruction with special education teachers through Zoom, considering the recent concerns with Zoom bombing? Jennifer, do you have thoughts on that?
Yeah, well, I think they clarified that it was about doing group instruction with special ed teacher doing group instruction with special education students. And I just want to clarify, just like a regular class, the fact of your class, you're not disclosing confidential information. Now, I wouldn't start that Zoom, just like you wouldn't start a class and say, the reason you're all in here is because each of you have IEPs and the IEP team decided that you needed specialized instruction. Of course, you're not going to do that. And I guess, you know, so you wouldn't start the group instruction on Zoom that way either. I think there's a second part of that question. So the fact of having a class, no, you know, the students might know they're in a special ed class and they might know thus, you know, the other students in the room also have IEPs. That's not what we're talking about as far as confidentiality. It would more be disclosing individualized information, such as the teacher pulling out in the IEP and say, well, how are you doing on goal 4? You know, you were supposed to be working on that in front of other students. That would be problematic. As far as the Zoom bombing, I think that brings up multiple questions that we've all been dealing with, and certainly maybe it's heightened if one were to Zoom bomb into a special education class, and if you were saying some sort of, especially if it was a one-on-one, I suppose, and you were disclosing information. I think one thing we all want to focus on is that should not be those kind of conversations. This is not a good place for it. So Zoom and telecommunications isn't a good time to review an IEP with a student and get into very confidential information. We're using it to facilitate remote learning. You know, if you're doing it to go over a lesson, the content of the lesson they're working on, the substance of the curriculum, that's not confidential whatsoever. So even if someone did Zoom bomb into it and they find out where you are in the curriculum, you know, no concern there. It would be, you know, you wouldn't want to pull out their evaluation and say, well, you're having a hard time. I see your parents are divorced and you're really struggling with that. Not the time for that, you know. So again, make sure the flow of information does not otherwise reveal things, and then the Zoom bombing becomes less of a concern, although we have concerns about Zoom bombing. And Jackie, well, all of us, actually, the 5 of us have had many robust conversations about balancing on one side this effective tool, we're using it right now, and many are using it to good effect for instruction. It's simple, there's a lot of benefits to it, versus I know we have concerns that their terms of service do not meet certain legal requirements, and our typical expectations for vetting have not occurred with this platform. I know one of you I know will jump in on that, because that continues to be the case.
Yeah, I'm happy to jump in. And as Jennifer said, I think we're all balancing here the use of these technology tools and our desire to connect with our students with the data privacy and technology concerns that inevitably arise when you're using these types of tools. You know, Jackie and I sent out an alert on this a couple of days ago, and I think our, you know, advice is really just try to triage as best as you can. You know, if you have access to technology that you've already vetted, that you already have a robust data sharing agreement, many of you use Google, and you can use Google Hangouts or Google Meets through an existing vendor agreement where you know that it's already secured in the best way that we can. Obviously, those are the tools that are go-to first. I think the second level are those tools you might not have a current contract with, but they're designed specifically for education use. So Zoom for Education, or again, some of the products out there that are designed and sort of have education in mind, and also have safeguards that can be utilized. Obviously, if all of those else fails and you're using some of these more basic, Zoom Basic, the other things, you know, we also put out some information about things that you can do even within those basic platforms to protect student privacy and just to protect yourselves from being Zoom bombed, which nobody wants to have happen. So we definitely suggest you utilize, you know, only sending out the links for those to people who are going to participate, using waiting rooms and passwords and all of those other important items to make sure that you're not getting Zoom bombed.
That's right. And I know how painful it can be, because I feel like I'm constantly, someone's trying to Zoom bomb me in this house. So it's a challenge. All right, Shelli, we had a question about summative paperwork. Does it need to be completed by the evaluator beyond the final rating, or is it sufficient to provide the summative rating and note it was not completed due to COVID-19?
Well, I mean, I think that's a really district-specific question, because I think different districts handle their summative paperwork differently. So many districts, for instance, in order to get the summative rating, will actually complete the entire document, and that's how you determine where the teacher is going to fall. So I think, you know, the guidance that's come out thus far has been, I think I referenced this in our last webinar, is that if you have all the data points completed and all the observations completed, you should handle that final summative conference, including filling out the paperwork virtually, and give that teacher a rating. On the other hand, if you have not had all the data points completed, or you weren't able to complete an observation, then you will not complete the summative, and it would just default to a proficient rating. There is still that push out there from the unions that I think we're likely to see some proposed legislation on, related to whether or not there could be a default to an excellent rating if they had received an excellent rating on their last summative. That is not currently what the law says, but I think that default to proficient, and perhaps noting that that's why you didn't complete the evaluation somewhere in their file so that they have it, is important to do, just so that we have a record of kind of what happened in the event that at some point we'd never remember what 2020 brought, and that why we weren't completing evaluations at that time, which is unlikely, but you know, just in case.
Jennifer, we had an interesting question about what happens if a parent doesn't show up for an IEP meeting, about whether or not the meeting can proceed. Could you quickly give us some thoughts on that?
Yeah, ISBE's guidance says that you need parent consent to use alternative means of video conference or teleconference. They don't provide a site and what legal authority they relied on in giving that guidance, and it is not consistent with what other states are guiding. So I participate weekly in a call with special ed attorneys around the country, and this is somewhere that Illinois guidance is discrepant, and I don't think that it's practical. So it puts you in a box where you are going to make a procedural violation. Either the IEP is not going to, if the annual review is due, either you're not going to follow ISBE's guidance and have a meeting with, and the parent won't consent to an IEP meeting by alternative means. Having a meeting in person is not an option. So either you're going to be late or you're going to violate that consent requirement. I think the consent requirement is just in ISBE's guidance. It's not in the regs, it's not in the statute, but the annual review deadline is in the regs and is in the statute. So given the two, and given, I think, what I'm seeing of my colleagues across the country, I think it's better to follow our normal 3 notices and hold the meeting without the parent, and then reconvene if they want a meeting later.
All right. Thank you so much, everyone. We have finished our hour. I know we got to a lot of questions. We didn't get to them all. If there's anything that you're seeking more advice on, please feel free to reach out to one of us, and we will look forward to seeing you next week. Thank you so much, and see you next time.
Thanks, everyone.
Thank you.
Bye.